Welcome everyone to the Notary Public Day Extravaganza. This is Marcy here, and I am very excited to have Richard Horn. Richard, welcome to the Extravaganza. We so appreciate you joining us today.
Thank you for having me. This is going to be great.
It's going to be amazing. Now, I want to briefly touch on, I think this is amazing. You actually, because everyone's like, oh, RESPA. Now, I have heard Richard speak before, and so he's very well versed. But you actually worked for both the CFPB and the FDIC. Is that correct?
That is right. I worked at the FDIC both as a law clerk and when I was in law school. I worked there for about 2.5 years while I was in law school as a law clerk. And then I went back to the FDIC as a senior attorney, both times in the New York regional office there. So it was a great experience there. And then when the CFPB was getting started, really in its earliest days, I couldn't pass that opportunity up. As much as I love the FDIC, I couldn't pass up the opportunity to really help stand up an agency. So I went to the CFPB in DC, and that was a great experience also, where it's kind of my claim to infamy. I led the TILA RESPA Integrated Disclosure Rule, or TRID for short. So the loan estimate and closing disclosure are kind of like my babies. They're now out in the world wreaking havoc, but I'm proud of them.
Well, we couldn't ask for anyone more well versed here than to lead us on this RESPA review. So, if you haven't joined us before, I welcome you all to talk amongst yourselves in the chat. If you have any questions, please put them in the Q&A. We'll ask as we go, and we're certainly going to have Q&A at the end. So don't think that we won't get you. We will. I'm going to take myself off screen because I know you want to hear what Richard has to say. Richard, you are all set and ready to go.
Great. I just want to make sure you see the slide here. It should be like
So you
just a
do see
full
the
picture of the
slide.
slide.
It's
Okay.
perfect.
Okay, because I didn't know if I got the right screen or not, and it's hard for me to hard for me to tell
Yes. Nope, you're
from this
good.
angle here. Okay, great. So I'm going to talk about RESPA, as you probably know, and hopefully that's the reason you're here. If you were hoping I'd talk about another topic, you can email me or call me. I'm happy to take questions on TRID or other regulatory issues. I deal with all consumer finance regulatory issues in my private practice now at my law firm. But today we're going to talk about RESPA, and in particular, RESPA Section 8 is going to be my focus here. I think one of the important things to know about RESPA, who's that handsome guy? Oh, that's me. Okay, great. Um, One of the important things to know about RESPA is that it's not just RESPA Section 8. So you might hear people refer to RESPA and RESPA's other requirements and the other parts of RESPA, but it could be that they're referring to RESPA Section 8. It could be that they're referring to the servicing requirements under RESPA or some other part of RESPA. And it's important to know what the other parts of RESPA are. So I wanted to cover that here and really get down to give a good foundation on what RESPA itself is. It stands for the Real Estate Settlement Procedures Act. It's a statute. It's in the United States Code. And when Congress enacted the statute, Congress said they had essentially two major purposes of the statute. One is to provide consumers with greater and more timely information on the nature and costs of the settlement process, and that kind of covers the disclosure aspect to RESPA, which I alluded to before. The TRID rule implements RESPA's disclosure requirements. But the other important part of RESPA's purpose is to protect consumers from what Congress called the unnecessarily high settlement charges caused by certain and what they called abusive practices that have developed in some areas of the country. And I think that's really getting at the RESPA Section 8 provisions, which deal with referral fees for referrals of settlement service business, referrals in the mortgage and real estate space. So those are kind of the two major areas of RESPA, but it does cover other issues as well. So I included kind of a list of all of the broad statutory requirements here. The first bullet is the good faith estimate and the settlement statement. Those are the disclosure requirements, good faith estimate or GFE. I'm sure you all remember HUD's former GFE form and the HUD 1 settlement statement that was implementing those two requirements under RESPA, as I mentioned before. Now those are implemented under the CFPB's TRID rule that I led. And so those statutory requirements are now implemented with the loan estimate and the closing disclosure, or the LE and the CD for short. There's also the home buying information booklet that's in the statute. That's an informational booklet consumers get when they apply for a loan. There's also a really a broad set of servicing requirements in RESPA. Um, and a lot of lawsuits that people say, oh, they're RESPA claims. A lot of lawsuits by consumers are when they're in the foreclosure or default process, and they raise all sorts of claims about the servicing of the loan. And a lot of those claims, even though they're called RESPA claims, are actually about these servicing requirements, not RESPA Section 8 claims about any referral fees. So there's a application disclosure dealing with servicing, there's a servicing transfer disclosure, there's a requirement for servicers to respond to borrower inquiries, and then there's also requirements surrounding force-placed insurance. And all of those are statutory requirements, and the CFPB has a rule that implements those statutory requirements. And then there's a Section 8 prohibitions on referral fees and kickbacks. And then there's Section 9, provisions that prohibit sellers from requiring a particular title insurance company. And then there's escrow account requirements that basically put guardrails around how much consumers can be required to put into their escrow accounts at closing and during the term of the loan, and also requirements to provide consumers with statements about how much they've put into the escrow account, and distributions from the escrow account and such. And then there's a prohibition against fees for preparing required disclosures, like the TILA disclosures, the settlement statement, and the escrow statement that I just mentioned. So those are all the statutory requirements under RESPA. But we're going to focus on RESPA Section 8 here, and that is, as I mentioned, it's a prohibition. Actually, I should stop here before we get into really all of the weeds about RESPA Section 8, and say, feel free to ask questions throughout. I know Marcy said she's going to be tracking the questions. I can't see them from here. So if there's a good question, Marcy, feel free to interrupt me. Or you can save your questions for the end. I'm happy to answer questions at the end of the
Yep,
presentation as
we'll do.
well.
Everyone put them in the Q&A, and I will stop Richard, or we'll hold them to the end depending on where we are. Absolutely.
Fantastic. Great. So RESPA Section 8, the statutory language, I will read just so you can see what the statute actually prohibits. It says, no person shall give and no person shall accept any fee, kickback, or thing of value pursuant to any agreement or understanding, oral or otherwise, a business incident to or part of a real estate settlement service involving a federally related mortgage loan shall be referred to any person. Well, that's a mouthful. And basically, what it's saying is, hey, you can't pay and you can't receive referral fees in the mortgage space, and it's limited to what are called federally related mortgage loans. That's basically the definition of a mortgage loan that is subject, or the name of a mortgage loan, I should say, that's subject to RESPA. And there's a very specific definition of what a federally related mortgage loan is. Won't get into that here, but basically you can expect that any residential mortgage loan that you're dealing with, from a mortgage company to a large bank, that involves a consumer buying or refinancing a home, that's basically going to fall under this definition. The one area where I have seen lately, where loans might not fall under RESPA or TILA, that has been coming up quite a bit, is business purpose loans, where the consumer actually has a business or commercial purpose for the loan. Even if it's a residential property, it might not be covered under RESPA or TILA, depending on really what that purpose is, what the consumer's true purpose is for the loan, and I guess what their primary purpose is, because sometimes consumers have multiple purposes. So that's something that might come up in practice, but generally most of the loans you're going to deal with are going to be subject, if they're to a consumer and dealing with residential real estate, it's going to be subject to RESPA. Regulation X is the CFPB's regulation that implements the statute. That is essentially, uh, it gives color to the statutory language, because as you can see, the statute is really not well worded. It's very broad. Who knows what it really means? And so agencies put out regulations to put more meat on the bone for what is a violation and what isn't. And the Regulation X, which I'll refer to as Reg X, is the CFPB's regulation, formerly HUD's, which we'll get into, And Reg X actually defines a referral as any oral or written action directed to a person that has the effect of affirmatively influencing the selection of by any person of a settlement service provider. So if you tell somebody, hey, you really should use lender A, and that consumer goes and chooses lender A, well, that's you've referred that consumer to lender A, you've affirmatively influenced their selection of lender A. And so that's, basically what this is saying is a referral, but it can be any oral or written action. So, posts on your website, or even this has gone as far as some regulators saying, essentially like um, uh, comments, on online or things like that. Those can be referrals as well. Um, referral can be pretty broad. Even banner ads on websites and things, which you could say is really just an advertisement. Someone could say, well, it is a referral. And so even though you have a regulation defining referral, it could still be viewed very broadly by some regulators. And so it's good to keep in mind that, you should be asking yourself, well, is this a referral or not? Um, and then Regulation X says, well, a referral is not a compensable service. So what they're saying is, hey, you can't actually pay for referrals. You can't say, well, not, I'm paying for, a service, but it's actually the service is actually the referral. Regulation X is saying, well, a referral can't be a service that you can pay for under RESPA Section 8. It cannot. RESPA, I should say, regex also says that required use counts as a referral, and they define required use as a situation in which a person must use a particular provider in order to have access to some distinct service or property, and the person will pay for that settlement service. So, where required use does come up is like in a home builder scenario where the builder says, okay, well, if you use my lender, affiliated lender, then you can have a discount on your countertops, something like that. You can get the better countertops. That is typically, a typical example of what required use is, but it can come up in other contexts as well, and that counts as a referral under RESPA. Also, this only applies to referrals of settlement service business. So settlement service business is defined under the statute as basically anything provided in connection with the real estate settlement. So that sounds pretty broad, right? Well, Reg X has a long list of very specific services that are included, and I should mention here for this audience that something that regex specifically includes in the definition is notarization of documents. And so regex does give that very specific definition. That's something this audience should note. What are the elements of a violation of Section 8? Breaking apart that broad statutory language, you can see that there's essentially four elements. So again, the giving or acceptance of a fee, kickback, or thing of value. And note that this is giving or acceptance. So either paying the fee or receiving the fee. Both sides of the transaction could potentially be in violation of RESPA. And we've seen that with some CFPB enforcement actions where CFPB has gone after both a lender and also a real estate brokerage. The next is an agreement or understanding. So sometimes there'll be a written agreement that a regulator could point to, but sometimes it's just this general understanding that, hey, if you send me referrals, I'm going to give you X, Y, and Z. And so CFPB says that they're going to look at the facts and circumstances to see whether there is an understanding. And sometimes it, is not a formal agreement, but is also in writing through emails. CFPB and every investigation and other regulators as well, they dig into emails. So if there are emails going back and forth that say, hey, I don't, I'm not going to pay you this unless you give me referrals. something like that. Well, that email shows an understanding that whatever is being paid is in exchange for referrals. Again, the referral has to deal with a real estate settlement service, and there's a long list of what those are in Reg X. And there also has to be an agreement that there'll be a referral. We talked about the definition of a referral, and those are the four elements. One thing that comes up, and I should mention, is people say, well, does this mean I can't refer business to anybody? Should I just keep my mouth shut when a consumer asks me who I should use? And the answer to that is no, you don't have to keep your mouth shut. You can't get in trouble just for referring business to a lender and not having the other three elements, right? So as long as you know you're referring that because you think the lender provides good quality of service, they have great interest rates or low closing costs, and that's the reason you're referring them, and it's not because you know you're going to get a kickback of some sort or something of value, then it's okay. You can refer business all day, every day, as long as you don't have the other elements where you know you're going to get something in exchange for that referral. Note also this thing of value. Um, it is a very, very, very broad concept that is in the regulation, and the regulation has a definition of it. So it's not just cash payments. Like you say, I'm going to give you $100 for every referral you send me. That would be a violation. It is anything of value, and this Reg X definition of thing of value includes tons of different things, including things, if you see the second bullet on the left. So this is a very, very, very broad definition, and it even includes things like opportunity to participate in a money-making program. It includes discounts. It includes trips. So the regulators will look at what's being exchanged and try and fit it under this thing of value definition. And if there is something being exchanged, the regulators will point to that and say, hey, that counts as a thing of value.
Richard, can I ask a question?
Sure.
Sometimes you'll hear people say, well, there's a dollar amount as to what the value is, right? If it's under $25 or $100, that's okay. Is that a thing? Is that true?
Yeah, so I was actually going to cover this on a subsequent slide, but I'm
Oh,
glad
great.
you
We
raised this
can
because
wait
this is
then, but I just wanted to throw that out while we were here. So that's fine.
no. I'm glad you raised it because it's good to discuss it here as well. There is no de minimis exemption from this definition of a thing of value. So, even if it's I'll buy you a cup of coffee. If you send me a referral, that would be a thing of value. Now, will the regulators go after that? That's another question, whether they're practically going to use their limited resources to go after something like that. But technically, even one cup of coffee is a thing, right? So it counts towards the definition. And I know this one attorney at one point asked HUD when HUD administered RESPA asked regarding I think a title company was going to bring donuts to a real estate brokerage's office, and so they asked, hey, could they bring donuts? And the response from HUD was, even a donut is a thing of value. So there's really no de minimis exemption, and you might hear that, and I think people when they talk about that, they're thinking more practically, like is my regulator going to go after me for this cup of coffee or not? But technically, anything would fall under the definition.
Great. Thank you.
Yeah. There's also another section that you might hear referred to, it's Section 8B. It really deals with fee splitting. It talks about not being able to split a fee with somebody who didn't perform services for that fee. And HUD, in their regulation acts, extended this to include charging for unearned fees. So not just fee splitting between two parties, but one party charging for fees that they didn't they didn't earn. And this issue came up in a case that got to the Supreme Court called Freeman v. Quicken Loans, where the Supreme Court said, no, 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 HUD, you can't do that. The statute only prohibits fee splitting between two or more persons, not just unearned fees from one person. And so, despite this language still being in CFPB's version of Regulation X, actually, because CFPB went and restated HUD's regulation when the authority under RESPA was transferred to the CFPB, um, this is not this is not a provision that can be used to go after one person charging an unearned fee. It has to be a fee splitting between two or more persons. Um, you may have heard of some very important exemptions from this RESPA Section 8 prohibition. There's a couple of them. I think the one that gets used the most is what's called Section 8C2. But actually, I should back up and say these fall under a subsection of Section 8 called Section 8C. And that section begins with the phrase, nothing in 8C shall be construed as prohibited by RESPA Section 8. So basically, it's saying anything that falls under RESPA Section 8C is not prohibited under Section 8. And then 8C2 is one of those provisions. And this says paying any bona fide salary or compensation for services or actually performed or goods actually provided, facilities actually furnished. Um, that would be okay under RESPA. It's not a RESPA Section 8 violation. And, that is, again, broad language. So Reg X provides additional gloss on that. And actually, they impose a couple, I would argue, some, additional constraints on that exemption. One is they say that the payment has to bear a reasonable relationship to the market value of the goods or services actually provided. I think they're interpreting that term bona fide in that way. Um, and so you might hear this referred to as the fair market value of the services or the reasonable market value of the services. People use different terminology for it. But basically, AC2 is saying, as interpreted by this regulation, that if you're actually paying for services and you're paying for the reasonable market value of those services, then it's not a violation of RESPA Section 8. This you might hear this used the most often in the context of what are called marketing services agreements, and those are the acronym is used quite frequently, MSAs. MSAs between lenders and real estate brokerages or title companies and real estate brokerages, where the lender or title company pays the real estate brokerage a certain amount per month for certain marketing services, and that could be um, advertisements at their open houses or sending emails to their list of consumers, signage at their office, things like that. So the argument is that if you're just paying the real estate brokerage for those marketing services, it's not a violation of Section 8A because it falls under AC2. You're paying for these marketing services, you're paying the reasonable market value for those services, so it's exempt. And then the question comes up, is that really is what the lender or title company is paying the reasonable market value for those services? That's a factual question. Sometimes it's easier, sometimes it's harder to answer whether that's true or not. But there is an argument that these types of arrangements do fall under Section 8C2. Um, CFB in the past has had a lot of consternation over these agreements. They do look at them in examinations to see whether these are actually payments for referrals or not, or if there is actually just, it's actually just paying for the marketing services. And so we're going to go through some of the CFB's guidance on that. Um, but the other thing to note is if the payment is going to a party that actually is already in the transaction, so the real estate brokerage, for example, the services that are actually provided have to be distinct from what they're already doing in the transaction. So where this comes up is with like referrals by real estate brokerages to home warranty companies. HUD put out an interpretive letter basically saying, okay, home warranty companies, if you're going to pay real estate brokerages for services, and you're not paying for just their referrals of consumers to your home warranty company, those services, you can't be their typical real estate brokerage services, right? It has to be something distinct from what they're doing as a real estate broker. And that really applies to any entity involved in the real estate transaction, not just real estate brokerages, it involves attorneys and title agents and anybody else. So another exemption is Section 8C4, that deals with affiliated business arrangements. And under the statute, affiliated business arrangements just have to satisfy three requirements. One is they have to provide a disclosure of their relationship. They can't be required use of a provider, which is, as I mentioned, was defined in Reg X. And then three, the only thing of value that's received by the owners of the affiliated business arrangement is a return on their ownership interest. So you can't have payments for referrals still. They basically, the owners of the affiliate business arrangement have to get paid an amount that's based on their ownership interest only. The definition of affiliated business arrangement is essentially um, in ownership of one more than 1% in the company. And you'll see this come up with what are called joint ventures or JVs. Again, typically between mortgage companies and title companies and real estate brokerages, where they'll create like a JV mortgage broker or a JV title agent, and essentially the real estate brokerage become, or real estate agents these days, they've been extended to real estate agents as well, will become a part owner of this new JV mortgage broker or title agent, and the real estate brokerage refers business to that JV. The real estate broker or agent can't get paid for those referrals, but they can get a return on their ownership interest in the JV. Um, there is a policy statement from HUD that's now decades old, and we'll talk about HUD's policy statements. That HUD intended to root out sham ABAs, basically ABAs that are meant to just kind of sweep referral payments under the rug. And they're meant to look like real operating businesses, but they're really not. It's just meant to siphon referral fees to a referrer business. Um, this policy statement has something you might hear referred to as a 10-factor test. HUD basically put out like 10 factors that HUD said this is what we're going to look at to determine whether an ABA is actually a real ABA, a bona fide ABA, or just a sham ABA that violates Section 8. And we'll talk about that. But even these days, companies do try and refer to that policy statement to try and hit as many of those factors as they can. And courts have still, at least some courts and regulators have still looked to that old HUD policy statement. We'll talk about that in a later.
Richard, I have a question, or we have a question in the chat.
Please.
That some title companies require consumers to only use their notary company that they either directly own or is through a subsidiary. Is that exempt from Section 8?
Well, so if you are talking about required use, there one of the statutory factors for whether an affiliated business arrangement falls under the exemption for affiliated business arrangements is that there can't be required use. Typically, well, I should mention the Reg X also has an affiliated business arrangement disclosure, because Reg X does implement this exemption with a little more meat on the bone, and they provide a standard form of disclosure that says to the consumer, you're not required to use this provider, this affiliated provider. Here's the estimate of their charges. You can go out and shop for your own provider. And so I think it becomes a two questions. One, um, are they providing the disclosure? Two, are they actually requiring the use, or is it just that consumers aren't going out and shopping and you know just using that company instead? So those are the things that I would I would look at. I can't say from my own standpoint right now, whether or not that violates RESPA Section 8, but those are the two things that I would look at. Regulators have pointed out in past enforcement actions on ABAs that the companies were not providing the disclosure, or the disclosure didn't comply with the requirements, or this or that. So, sometimes even providing a non-compliant disclosure can be a problem. Um, there's another Reg X exemption that I wanted to mention. Well, two. One is for normal promotional educational activities. This is used quite frequently for companies in this space. These activities to be exempt can't be conditioned on referrals, so you can't only provide them to companies that are sending you referrals, and they can't be set up to defray the expenses of a potential referrer that they would otherwise incur. So you can't go out and pay for their office supplies, right? You know what I mean? Um, so that is that exemption. The second exemption is an employer can pay its own employees for referral activities. Seems logical, right? Let's move on to the next slide if I can get there. There we go. So there are some old HUD policy statements. These go back decades old. From the 90s. I think there is one from 2001 that's still referred to. When CFPB was created, they basically put out a notice that said, hey, we're still going to use these old HUD policy statements. There, the last bullet on this slide is the one talking about that HUD interpretive rule on home warranties, where they basically say a home warranty company can compensate a real estate broker for services that are actually necessary and distinct from their primary real estate brokerage services, but they can't pay for referrals. And that was from 2010, so it was a little more recent. But then just recently, just a couple years ago, CFPB went out and said, hey, remember all those decades old policy statements? Well, we're still going to use them. And they put out a list on their website of all of these old HUD policy statements that they're still looking to. And that includes the one on sham ABAs. There's a policy statement on rental of office space. So sometimes you'll see a mortgage company rent office space in a real estate brokerage's office. Sometimes it's just a desk that they're renting. You'll hear the term referred to as a desk rental. Well, that policy statement basically says, um, if you're paying the general market value of that space, then it would fall under 8C2. You can't base the amount you're paying for this space on the fact that you're a mortgage company getting space in a real estate broker's office that's really valuable to you, or you can't base it on, hey, well, other mortgage company down the street is paying X dollars, so I should pay X dollars. It's got to be what the general market value of that type of spaces and amount of spaces in your area. So oftentimes when I'm looking at these things, I look at what would it cost to rent similar space at like one of those work share offices that are sprouting up around different cities now, like a Regis or some other types of companies. So that's one way to look at it. There's even a HUD policy statement on the services mortgage brokers have to conduct to actually earn their mortgage broker fee. So there's all these old HUD policy statements that are sensibly still in play right now. Um, um, there's also this case, CFPB versus PHH, which got a lot of attention in last decade, but I think it's still important to talk about. Under former director Chopra, I mean, not Chopra, Richard Cordray, excuse me, I meant to say, CFPB went after mortgage company PHH for RESPA violations, basically alleging that they were only sending mortgage insurance business to mortgage insurance companies that would purchase mortgage reinsurance from their affiliated reinsurance company. And so they were basically basing the sending of mortgage insurance business, their referrals of mortgage insurance business on getting kickbacks, basically what the CFPB alleged to be a kickback, the purchase of reinsurance from their affiliate. Director Cordray said that this was a violation of Section 8A, even though Section 8C2 says it's okay to pay for the fair market value. So, that would essentially be if the mortgage insurance companies were paying the fair market value of what the reinsurance costs, that would be okay under RESPA. But Cordray said, no, 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 that's just a gloss on Section 8A. It's not a full exemption. It's just basically giving some interpretive guidance on how to ferret out Section 8 violations. And he argued that the term bona fide in the statute for the 8C2 exemption actually means that the purpose of the whole arrangement can't be to get referrals. Essentially, you can't have a tying arrangement to say we're only going to send you business if you purchase this service from us, right? Um, the DC Circuit actually, current Justice Kavanaugh, then Judge Kavanaugh on the DC Circuit Court of Appeals, disagreed with the CFPB's interpretation. He wrote the three-judge panel opinion on the RESPA issue and basically said, hey, it's not even a close call. The CFPB's interpretation is strained. He held that the Section 8C2 exemption is a full exemption. And remember how I pointed out to the Section 8C language that said nothing in 8C violates Section 8. Well, there's a famous line from this opinion that said nothing means nothing. He pointed to that same language and said nothing means nothing. So he said also with respect to tying arrangements, that's basically RESPA doesn't prescribe any tying arrangement. So you can have a tying arrangement as long as the parties are just paying the fair market value of the services that are being provided. It's okay if they're doing that, knowing that there are going to be referrals involved. And so that's a very pivotal opinion in RESPA world. That's why I wanted to cover it. Because of that opinion, CFB had to rescind an old compliance bulletin from 2015 that basically said, basically their point was under 8C2, we don't see how any MSAs could be legal because MSAs are always based on the understanding that you're going to be getting referrals from it. And so they basically all violate RESPA Section 8A. So they had to rescind that compliance bulletin and put all these FAQs on their website, kind of playing a game of Twister and trying to say, well, MSAs can be legal, but we're going to look really close to see if what's being paid for is really they're paying for referrals and not just marketing. And we're going to look to the facts and kind of saying, yeah, PHH happened, but we're really going to look close to see whether there's a violation. And part of the reason I mentioned referrals earlier is because they go into some discussion in their FAQs on their website about what they consider just marketing and what they consider a referral. And here in their FAQs, what they say is marketing is directed to kind of the general public. It has to be a wide audience. They say, as an example of what marketing is, advertisements and newspapers, trade publications, or on a website, that would be considered marketing. But referrals are more directed to a person. And one example of a referral that they said they wouldn't consider marketing is handing directly to clients the contact information of another service provider. Even if an MSA says, apparently under these FAQs and the CFPB's view, even if an MSA says we're going to pay you to hand our business cards out to your clients, the CFPB would say, hey, you're actually paying for referrals. And remember, I said, or in an earlier slide, pointed out that Reg X says a referral is not a compensable service. These FAQs are basically saying, yeah, you can have a marketing services agreement, but you can't have it be paying for referrals. It has to be actually paying for what they consider marketing. Um, and the other points they make here is that you have to pay for the marketing, and it has to be the fair market value for those services. If you're paying in excess of the fair market value of what those services are, then there's really going to be a payment for referrals. So if a mortgage company says, hey, real estate brokerage, we're going to pay you $100 a month for, well, I should say, we should make it more, $10,000 a month for you to put our sign in your office. Well, CFPB or another regulator could come in and say, yeah, you're paying a lot of money for that for that one little sign that's about the size of a business card in that office. We think what you're really paying for are referrals. So that's just a kind of a very, it's an example that's exaggerated, but just to make the point. The other thing is they say that, look, you have to make sure you're actually getting the services. You can't pay a party for marketing services and then have them not do anything for you, right? So mortgage company can't say we're going to pay $1,000 a month to this real estate brokerage, and then the real estate brokerage doesn't do anything for the mortgage company, and the mortgage company keeps on paying. That would also be an example of a payment that would the CFPB or another regulator would say was for referrals. Um, Then there's some more FAQs on gifts and promotional activity that I just wanted to cover. Again, this is where I was going to talk about there. That there's no de minimis exemption. I also wanted to point out on these FAQs, the CFPB actually says that you can't pay for referrals, and that includes even paying consumers for referrals. So in this FAQ, the question was, can a settlement service provider give a discount, gift, or refund to a consumer? And then the answer is, yeah, you can, but if it's in exchange for the consumer referring business to you, that would be a violation. So CFPB's FAQs, say, hey, really, you can't even pay consumers for referrals, even though you can just give them in general refunds or gifts or what have you. So, um, with respect to these gifts and promotional activity, I should mention there's some really good FAQs on this with examples and description of what it means for something to be conditioned on referral of business and what it means to defray expenses. I'll just mention for conditioned on referral of business, I think what the CFPB is going to look at is whether you're directing the marketing to just your referral sources or the general public. And the more you're directing it to the general public, the less chance that CFPB or another regulator would say you're conditioning these promotional activities on the referral of business, and there's some good examples of that. Also, for defraying of expenses, if you're um, paying for a referral source's continuing education or their licenses or what have you, well, those are expenses that that referral source would otherwise have to pay, so that would be defraying their expenses. Another example is if you're buying them their own office supplies with their own logos on it, well, that would also be something that they might otherwise pay, so that would be defraying their expenses. But the FAQ say if you're sending around office supplies with your own contact information and logo on it, well, that's not something that a referral source might pay, so that's less likely to be, considered defraying providers' expenses. And there are some good examples in the FAQs of what would satisfy the exemption and what wouldn't. And I know we're getting short on time, so I'll stop here to see if there are any questions. And if not, then I can keep on going through these examples.
So let's do a little bit of like scenarios. So
Sure.
let's say I'm a notary, I was a notary, and there are 10 title companies in my area that I want to, you know, let them know that I'm available for business. Can I drop in with a box of donuts and coffee and be like, hey, my name is Marcy. Here's some business cards. Here's some donuts. If you ever have, any business, please give me a call. Is that allowed or not allowed?
So yeah, going back to the discussion in the FAQs, I mean, that's a great question. It would really depend on how targeted this is. So if you had, 20 title companies in your geographic area, 10 are the ones who send you business, and you only go to those 10, bringing them donuts or whatever, that would give a regulator more of an opportunity to say, well, you're targeting this narrowly to your referral sources, so it might not satisfy the exemption. On the other hand, if you went to all 20, whether they refer business to you or not, with a box of donuts and your information and maybe a pamphlet on your services and your costs, because you're targeting it more broadly to all of the providers in your area, whether they send you business or not, um, based on the examples in the FAQs, it would be much less likely, I think, for the CFPB or regulator to say that this was conditioned on the referral of business. It
And
seems
would that change if I went there instead of like donuts? What if I brought them a box of pens with my logo on it, some post-it notes, Would that be different because I'm not deferring any costs? Like, could I do that to only 5 title companies and not all 20? Or would it still be the same thing?
So I think what the FAQs say is, look, if you're paying for their general office supplies, so you're bringing them just in general boxes of pens and paper and other things, the post-its that they might use, that would be um, potentially considered defraying their expenses because they would otherwise have to pay for those office supplies. But there is this part of the FAQs that say if they have your logo on it, it's part of your whatever branding or contact information. That's part of your promotion to get them to remember you. Um, that company probably wouldn't be going out and otherwise buying office supplies with your branding on them. So that's less likely to be considered defraying of expenses, and so it makes it more likely to fall under the exemption. So it seems like office supplies, just based on these FAQs, office supplies with your own information on them would be safe considering these FAQs.
Okay. Now let's go to a broader conversation. So,
Sure.
as a notary, there are thousands and thousands of title companies and signing companies out there who hire notaries. Let's go outside of my geographic area. Let's say I have, I know that there are 5 of the largest title companies out there, right? Underwriters. And I want to send them, wherever they are. So I'm in New York. Let's say one's in Virginia, 2 are in New Jersey, whatever. I'm going to send them a box of chocolate or some coffee for their staff. Does that make it is there difference in there because physically they aren't where I am, and the reach is, I mean, sort of global at this point, right? I know
Right.
these were written, we're talking about in my particular area in person, but now because work doesn't really have boundaries, how does that affect this conversation? Or
Well,
does it not?
it's a great point. So, the FAQs talk about kind of geographic area, given locality. And, I should mention back to the last question when I said, um, you know, items with your logo is safe. I should mention, that, and it is important to keep in mind here, there's these two elements you have to satisfy for it to fall under this exemption. One, it can't be conditioned on referral of business, and it also can't be to defray their expenses. So it the the providers you're sending this to is an important component of the exemption, and um, the regulation itself doesn't talk about geographic locality, but it talks about referral of business. So if you are limiting this to companies that are just sending you business, I think that's really going to be the first place that a regulator would look, not, on where these companies are located or how broad you went. So, I would look at, you know, the list of companies you want to send this to, or whatever you're sending, or, even if it's just one of the FAQ examples mentioned like a drawing for a mini basketball set. Actually, it's a good example to talk about. I'll go back to that. Go back to that slide. They said that entries are automatically made for all previous customers and all LOs, loan originators in the city, regardless of referrals. Well, it's going broad. Like your metric isn't who sends you referrals or not. It's going to a broader set. So if your set of providers was broader than who sends you referrals, if it's tri-state area, or companies over X dollars in assets in this particular market. That's something you could point to a regulator and say, well, actually, I wasn't conditioning this on referrals. It's just, I was sending it to this neutral uh, set of companies, essentially.
Okay, now so that makes a good point. So, and I want to drill down on that for a minute. So, what about sending a little thank you? Like so I targeted all of the title companies in my area. I dropped them all off donuts. It's all good. Now, one of those title companies starts to use me. Can I send them a virtual cup of coffee? Hey, I really appreciate the work. Thank you so much. here's a little thank you for sending me work.
I hate to be the person to say no. Um, but just looking at the plain language of the statute and regulation, sending something in exchange for referrals could open the door to a regulator looking for a violation because they could say, well, you did it the first time. Maybe there wasn't an understanding that you were going to do that again, but in the future, maybe this company says, oh, I want to keep on sending business to XYZ company because they always send me, coffee every week, every month, or what have you, right? So it could open the door to scrutiny. And, once you start down a path, does it where does it end up, right? You're gonna up the ante if they send you double the amount of referrals, and then and then the regulator really have something to point to, are there emails that you inadvertently send that say, oh, when they say thanks for the coffee, you say, yeah, keep on sending referrals, I'll send you more, something like that, right? So,
I'll send you more coffee.
right,
Um,
right.
all right. So now we know. So now we know thank you after the fact, probably not a good idea. But
Well,
what
just saying
about,
thank you, just saying thank you, is that a thing of value? That's a great
sure.
Great question. I've seen regulators, like I said before, really look more broadly at what a thing of value is. I don't think that just saying thank you is prescribed by RESPA, so I don't think that in and of itself, like the words thank you, would be a violation. So I don't want to say you can't say thank you, but it's that extra things of value that might go along with it that could be a problem.
Okay, let's talk about holidays. So, it's Christmas, it's Hanukkah, it's Thanksgiving, it's Easter, whatever it might be, and I send a little fruit basket to one of my clients, to all of my clients. Let's go back. What if I send all of my clients a fruit basket for Christmas? Is that allowed or not allowed?
Again, I think based on these FAQs, it depends how broad you go and whether it's considered defraying their expenses. I mean, I think, is a regulator going to say that you're paying for fruit they would otherwise purchase? I don't know, but I think it does. uh, there is a potential, depending on what you're sending, for there to be an argument that this is a payment for a referral because it doesn't fall under the exemption, depending on what you send, how limited you send it to, just referral sources or not.
All right. So, um, I think that that's probably the majority of what those of us in the notary are looking for is to what can we do to, set ourselves apart without breaking
Right.
any of the rules. And certainly
Yeah.
there's an opportunity here. You could still do some things as long as you were being fair and broad about it. Certainly, it sounds like, dropping off some, pens or post-it notes might not be horrible if you're doing it to every single title company in your particular area. Can I just talk 1 minute about promotional items? Let's say I
Sure.
open my office or I have a booth or I have a stand at a title company event, right? Or a
Okay.
mortgage broker event. And I bring all sorts of fun stuff to give out while I'm there. Allowed or not allowed?
So, that's a great question. I think it depends on, well, one thing that comes up with these types of events is, are you paying for that booth space and how much are you paying? Because if you're paying more than the fair market value, that could be considered to potentially be an issue because it could be considered a thing of value in exchange for future referrals, or understanding that you're going to pay up through the nose for some booth space from this title company, hoping that they'll send you referrals in the future. So there's that issue comes up with these. um, it depends on what kind of event. If it's an event that's broadly attended by the public and you're handing out materials to the public, like I've seen this occur with like local housing events put on by community organizations where you can have a booth set up. If it's that kind of situation, uh, you know, based on the FAQs, you might have an argument that, hey, this is marketing to the general public. This is, basically paying for that space. You're paying the fair market value for whatever space you're using, so it should be okay. But these are all fact. Every situation that comes up with these situations that involve settlement service providers are so fact specific, and they do require an analysis to see what are the RESPA risks. Unfortunately, with RESPA, it's such a broadly worded statute. The regulations, they try and put more meat on the bone, but it is also broad that, they also have FAQs, and the FAQs don't answer every single situation that may come up. And so unfortunately, it's hard to say yes or no to all of these hypothetical scenarios. But hopefully hopefully my answers are providing some insight on how to look at them.
No, absolutely. And we certainly appreciate it. This was great because I am a huge advocate of knowing what goes on outside of your industry when you're working with other related industries, and how that affects you. So I love that we got the background on what RESPA is and how it affects the industries that we work in. And it also gave a little guidance in the decision making that we as notaries need to make should we decide to use any sort of promotional item or do something like that. A, we know the risks involved, right? And B, we know when we're kind of, walking on a thin line, particularly. But
Right,
this was
right.
so informative. I'm so grateful that you gave us this wonderful presentation, and everyone who came. Thank you all so much for hanging in. I know there was a lot of interest and a lot of individuals out there who were really concerned about making sure they were doing the right thing. And Richard, this gave us the opportunity certainly to get better information, make sure we make good decisions. So thank you
Yeah.
so much. I appreciate you all so much for coming. I hope you have a great rest of your day. Maybe I'll see you at the rest of my extravaganza. Otherwise, have a good night and a good rest of your weekend. Thank you again, Richard, so much. We
Thank
appreciate
you.
you.